The State Capture Commission of Inquiry. With 2 years of testimony expected, mountains of evidence will be coming through. So how do evidence leaders sort through it all? And how do they create a case? Well, later, South Africa is welcoming Zimbabwe's Constitutional Court ruling. Where to for the rival parties from here? Those are my questions for our panels tonight. What's yours? You can contact me on 011-759-6340. You can also tweet us on #TonightWithJaneDutton. Time now for news headlines with Shahan. Over to you, Shahan.
All right, thanks for that, Faria. Appreciate it. These are our top stories. Something you mentioned, of course. Emmerson Mnangagwa remains Zimbabwe's duly elected president. The Constitutional Court has ruled against the MDC Alliance's bid to have the election results overturned. The country's Chief Justice says the party simply failed to provide any proof of irregularities.
The court finds that the applicant has failed to place before it clear, direct, sufficient, and credible evidence that the irregularities that he alleges marred the election process materially existed. In other words, there was no proof of the happenings of these irregularities as a matter of fact.
Former Deputy Finance Minister Mcebisi Jonas is making shocking allegations against one of the Gupta brothers. He revealed that one of the brothers threatened him with death if he disclosed details of the Saxonwold meeting. He also says the family told him Finance Minister Nhlanhla Nene would be fired. The Guptas then apparently offered Jonas the position.
He said that as far as he was concerned, this meeting never happened. And that if I were one day to suggest that this meeting had occurred, they would destroy my political career. At the end of the meeting, Mr. Gupta repeated that they had information on me, and if I suggested that the meeting had occurred, they would kill me.
And President Cyril Ramaphosa says healthcare for all is part of social justice and must be implemented at any cost. He was speaking at a consultative meeting on the National Health Insurance Scheme. Stakeholders questioned how the scheme will be governed. They also want to know how it'll be funded. Ramaphosa says despite the dire state of the economy, money will be made available.
We have a well-managed national healthcare system, or insurance system in our country. That is one of the dividends, that is one of the spin-offs that we could have. We must put behind us the era of quality healthcare being the exclusive preserve of those amongst us who have deep pockets. The NHI is therefore also fundamentally about social justice.
All right, those are the headlines. It's back to Vuyo.
Thanks, Shahan. Well, the state capture inquiry is expected to take at least 2 years to complete. There are 122 boxes of evidence to be read into the record and tested under cross-examination. Evidence leaders clearly have their work cut out. So what are they looking for and how do they prepare for these commissions? To talk about this, I'm joined by two attorneys, Vanessa da Silva Faria from Ulrich Roux and Associates, as well as Thamsanqa Malusi, who is from Richard Spoor Attorneys. Good evening to both of you. Thank you very much for your time on a Friday. Well, let's get straight into it. I mean, you sitting there, you are the evidence leader. Obviously, your interest is in making sure that the integrity of whatever comes through is indeed protected, and by extension, the commission gets to do what it is supposed to do. What are the first things an attorney with that task at hand, do?
Well, they'll obviously, first need to prepare the witnesses that are coming in. Then they'll need to go through the evidence with them and see what exactly is their task. The the persons who are leading the evidence and who need to conduct this investigation, which is essentially what the commission inquiry is all about, has a certain mandate to fulfill, and they have certain goals to reach. And they need to determine what evidence needs to be presented and what exactly they need to ask and question and deal with in order for them to reach their goal. And it's all an issue of listening to what your witness has to say, to understand what is it, and to understand what is the crucial aspects of your witness testimony, and to then assist them in delivering that properly before the commissioner.
I mean, if the one inquiry I once participated in is anything to go by, the evidence leader sits you down and goes through what they already know about you that is relevant to the commission. They ask very specific questions. What drives the line of questioning and even their choice of what to focus on and what not to focus on?
As my colleague says, each and every Commission of Inquiry has very specific terms of reference as to what it wants to achieve. So whatever questioning that comes out from the evidence leaders is geared towards those terms of reference. In this specific case with the State Capture Commission of Inquiry, the idea is to adduce evidence that proves or otherwise that there was influence within the executive branch of the nation. So, but also to answer the question that you asked earlier around what evidence is important, the witnesses do not just submit whatever evidence that they want to submit. In fact, the evidence leaders themselves, through the chairperson, which is Justice Zondo in this case, would actually have to ask for what the evidence that they want, so as to limit the scope of what the evidence, what evidence the witnesses can adduce in order to stop any irrelevant evidence being submitted by the witnesses, which might clutter the record.
Now, as the evidence leader, do you necessarily have to be committed to the cause? Let me make an example. Let's say we take the State Capture Inquiry. Do you have to be committed to that cause? Yeah.
Well, I would say yes. You know, the whole purpose of the commission inquiry is to essentially commit this investigation and find out what exactly has happened, and to get to the roots of the allegations of fraud and corruption, which are the allegations that the persons affected are currently facing. And because that is the purpose of the investigation, the evidence leader needs to make sure that that is what they divulge into and that is what they focus on to. Of course, if during the giving of evidence it leads to other issues, that can always be dealt with and that can always be addressed. And I think what's nice about a commission inquiry is that it's done in the public domain. And essentially, whatever you say, whatever you present to the chairperson dealing with the matter is also what you are presenting to the public domain. And if that leads to something else, then that also opens up doors for another investigation to be conducted. But insofar as in dealing with the purpose of the commission inquiry, the evidence leader needs to focus on what their goal is and what investigation they're conducting and what evidence they need to pull out of the witness that they're dealing with.
Well, I've had people, Thamsanqa, say, well, I will go there and say, you know, A, B, C, because I know that whether it's, I mean, the evidence leader is predisposed to the sort of issues that I want to raise. In other words, I know, for example, let's say state capture. I know that that person doesn't want or is you know, really wants to have a go at everyone who has been involved in state capture, and I'm going to do everything possible to like actually please them, because I know that's what they want to hear. Is there something like that, like predisposition on the part of the evidence leader in this instance?
I mean, ultimately we're all human beings, whether you're a lawyer, you're a judge, and you cannot divorce the lawyer from their predisposition. So obviously, depending on the inclinations, the evidence leaders do have predispositions, and they just have to be professional in how they deal with the inquiry and the questions that they pose, because ultimately I would assume that the evidence leaders are lawyers and we are bound by our ethics as lawyers, you know. So we have to, outside our predispositions, conduct our work in a way that is in the best interest of our clients. In this instance, the clients of the evidence leaders is the state. So we want to get to the nub of the truth in this situation. So outside of their predispositions, they are mandated and they're demanded by their ethical codes to act in the best interest of the state and get the true version of the events from the witnesses.
Now, you know, Vanessa, when the evidence leader stands there, they know that, one, they are being watched because this is a public, you know, inquiry. So not only being watched, but they are under scrutiny. There's a lot of peer pressure. There's a lot of, you know, the public good, like a lot of people want state capture, you know, to be unearthed and all the wrongdoers exposed. Now, what do these things do, you know, to, especially, you know, I mean, lawyers who are not really used to saying things or being, like in public, you know, do they play any, does that play any role?
Well, of course, they would be under a lot of pressure. And, you know, with a matter of this severity, they're definitely under a lot of pressure to make sure they do the right job and that they do a good job at finding out you know, what's actually happened in the matter and to conduct a proper investigation into everything. But I think what we must also remember is that there are certain regulations that have been put in place that regulates the process and that regulates how these evidence leaders need to address matters and how they need to bring in their witnesses and how they can assist the investigation and how they can assist their witnesses in, you know, giving their testimony and how they can drag the evidence out of them. So with the assistance of the regulations and with the chairperson presiding over the matter, their conduct and what they're supposed to do is very much controlled and protected at the same time. You know, so they know exactly what they need to do, and the chairperson has appointed a good team, a good legal team to assist him in this investigation. And of course there's pressure, but you know, pressure always makes us do good things for most of us.
The possibility of like trying to please, you know, trying to be seen to be this guy who is, you know, who knows what is going on and can speak to each and every question that anybody can raise, because this incredible amount of, you know, public scrutiny and this stuff playing itself out there in the open, millions of people watching. I mean, surely that, doesn't that sort of, can that lead to someone doing things that they would otherwise not do, simply because they know they are being watched and they are being scrutinized?
I think the same can be said about each and every other person, not particularly lawyers. You know, when there's pressure around you, obviously that makes you act slightly differently to what you may normally act if there was no pressure or public scrutiny around what you're doing. But I think my colleague is correct in that there are regulations that are promulgated to regulate the process for this inquiry, and more specifically to regulate the conduct of the lawyers or the evidence leaders and how they ought to be posing questions to the witnesses, etc. So that sort of controls how they behave in them blocking out the pressure that they're under in terms of getting the truth out from the witnesses. So I think anyone in that position would feel the pressure, and that pressure would have some effect on them. But the fact that there are regulations that are seeking to protect against that, that's sufficient to make sure that the lawyers and the evidence leaders that are there are going to act accordingly.
Okay, speaking of posing questions, we have Gloria on the line. She is based here in Johannesburg. Gloria, what do you have for us?
Will, how are you?
Well, thanks.
I'm okay. I just want to ask one question. How safe is Mgqithi Sitjuna after divulging this kind of information? How safe is he?
Well, I guess that goes for all witnesses. How safe are the witnesses who come before a commission of inquiry?
Well, it depends on the witness itself. The evidence that is presented in a commission of inquiry can be used at a later stage in criminal proceedings, especially obviously against the persons accused in the criminal proceedings. There is, however, a regulation that has been promulgated for this specific inquiry, which states that a witness who incriminates themselves that statement, which is self-incriminating, cannot be used against that witness in a criminal proceeding should that witness be charged with a particular offence. So a witness in that regard is protected, and that would generally deal with witnesses which we could, I suppose, in a criminal matter, you'd refer to them as a 204 witness, where they essentially admit to committing an offence, but their admission in committing that offence is essentially assisting the investigation in the brighter scheme of things. And those witnesses are protected in that their statements cannot be used against them should they be charged with a particular offence relating to their statements.
Yeah. Your thoughts, Thamsanqa?
I think Gloria's question is more of a social sciences one and less of a legal one. The nice thing about this inquiry is that it's public. So any witness that says something that is incriminating to anyone else, it's there for the public to see. Should something happen to that specific witness, then the first person that is likely to be a suspect in the event that something happens is whoever that witness said something about. So in this instance, Mr. Jonah saying something about the Guptas, they would be potentially the first people that the police would look into should something happen to Mr. Jonas. But there's nothing in the regulations or in any other law that provides for protection for any person that gives evidence in the inquiry. But I do think that the fact that the inquiry is public is enough of a protection to deter any other person that may have been incriminated in the inquiry from doing anything to harm any person giving evidence.
Okay, thanks, Gloria, for that question. Let's move on now to Zama, who is Peter Maritzburg. Hello, Zama.
Hey, Bill, how are you?
Well, thanks.
Okay, ngikukhuluma ngezulport.
Yes.
Yabo okhulunyiwe namhlanje kuzivulele open book into ade singayilindele. Which sengazi ukuthi ingaqhubeka le show lelo khuzane le inquiry ikhiphe wonke amaqiniso ungabi khona ezinye izinto ezoshiwa ngaphandle ukuze sonke la eSouth Africa silithola iqiniso njengoba linjalo. So nje ngicela ukuthi sonke into ingahamba ngendlela silithola iqiniso ngale ndlela leqale ngayo. Siyajabula ukuthi ngikhuluma nangayo le show.
Thank you very much. Well, Zama, of course, saying a lot was revealed today, and may the truth indeed be unearthed. I just want to ask also about, because I've never been privy to sort of this kind of relationship and what happens. What is the relationship between the evidence leader and the presiding officer, whether it's a judge or a chairperson of a committee?
Well, in a commission inquiry, the chairperson is the person who actually appoints a legal team to conduct an investigation. And the evidence leader is essentially the person who assists the investigation to be brought to light for the chairperson to consider and for the chairperson to determine whether or not the matter essentially needs to proceed to one of a prosecution. So the relationship there is that the chairperson finds a legal team that they think is suitable to deal with a matter. And generally the people in the legal team are people who have very good skills and are who are experts in certain issues pertaining to the matter. And the purpose of the evidence leader is to then investigate the matter and ensure that the chairperson is satisfied with the evidence that has been brought and that the chairperson can make a reasonable decision based on the evidence that has been brought before him.
Yeah. I mean, the chairperson and the evidence leaders both have the same objective, which is to unearth the truth in that commission of inquiry, whatever the case may be. So they both seek to serve the same objective. Their functions are slightly different in that the evidence leaders are the ones that go through the evidence and they tease out the evidence through cross-examination of the witnesses. And the chairperson has to digest that evidence and make a determination afterwards. So in as much as they have the same objective, their functions are slightly different in that the one in the form of the evidence leaders seek to get the truth out of the witnesses, and the chairperson controls the entire process, and they have to make a finding after the whole thing is done.
Okay, Thamsanqa, Malusi, Vanessa, Silva, Faria, thanks to both of you for your insights. I hope, of course, this was very useful to our viewers.